The next item on the agenda is the resolution regarding committee on turnaround. We've kind of had that conversation. Do we have a motion to adopt the resolution?
So moved.
Seconded? Second. So I want to say that I have some concerns that this resolution may be out of order, and I need to ask some preliminary questions and perhaps give guidance to how to change the resolution so that I feel that it's going to be appropriate. So BJ, let me ask you just quickly, and I know you and I, talked real briefly. What's your background for this resolution and why you feel it's necessary?
I think, that we're 2 years in with turnarounds, and I think it's time that where we can go back and look and kind of acknowledge our successes and celebrate them and see how we can share them, and accept our failures and see how we minimize those. Strictly with Dan and Tony and Sarah have been here since the inception of this. I thought they were best suited to do it, and basically just want to look and see, hey, what's working, let's share it. What's not working, let's try to fix it.
Okay, so I'm gonna talk to have my staff, my legal staff, address this issue. I think is it Maggie that's going to address? The resolution states that the Center for Education and Career Innovation will basically be staffing this committee and supplying the work and asking the department for information, and that's where there's a legality issue, and I'll let Maggie explain that.
Sure. So the legal staff at the department looked into things, and we acknowledge we're not board staff, but we're here to kind of clarify what the superintendent's opinion on this is. So in looking at things, there were two concerns we had. First, that the resolution implies that the board has powers and CI staff has powers that are not prescribed in statute. And second, that there is a wasteful duplication of efforts and resources of the state government by the assignment of authority in the resolution. So just to address the first issue there, we did find some case law from Indiana courts. Bell versus Board of Tax Commissioners states that an administrative agency has only those powers conferred on it by the General Assembly. Powers not in its legislative grant cannot be assumed by the agency nor implied to exist in its powers. So in looking at what exists in statute for board, there is listed under 2019-2-8 a list of authority of the duties, which include establishing educational goals for the state, assessing the attainment of the established goals, and assuring compliance with the established standards and objectives, which none of those really show that you have the authority to conduct research. And to kind of further that, there is actually a statute 2019-3, which gives that authority directly to the Department of Education. It says that the Department of Education shall conduct research on behalf of the State Board of Education. So that seems to override the authority that's already statutorily given to the department, to say that that is an implied power of the board. Secondly, the resolution does cite to 2031 8, 9, and 9.5 as authority for this, but again, that seems to imply that the board has the authority to move forward with this committee rather than giving it the authority to do so in regard to the work the committee would be doing or the staff of the committee would be doing. Again, because those particular statutory citations only refer to the board assigning grades for schools, assessing accountability, and intervening in the school and determining what the state board intervention would be. So that is first, the first point about the implication of powers that are not statutorily granted when those powers are statutorily granted to the department explicitly. Second, in regard to duplication of efforts, this kind of piggybacks off of what I've already said about the department's role. Again, IC 2031-9-4 does say that the department makes recommendations for improving any school that is placed in the fifth year placement, which are those that are in state board intervention territory. So if we are charged with the authority to make recommendations, that would seem to imply some of the work that you're saying in the resolution here. Additionally, as I stated earlier, 2019-3-4 states that the department is required to conduct analytical research to assist the state board in determining state's educational policy. So clearly this is a duplication of efforts, and it is preventing the department from doing the work that it is statutorily prescribed to be doing.
So an easy remedy, I guess, would be to do what we've been doing and operating, which would be to have the Department of Education staff in partnership with the State Board of Ed staff to carry out the work of the actual committee. I'm not implying that I should serve on the committee in any way, but this is a matter of actual which the department that has the authority to carry out many of the items that are listed in here for the work of the committee. Sarah?
I'm just a little confused. I want to make sure I understand the argument. Is it accurate to state that the Indiana State Board of Education has the authority to intervene in schools according to their performance?
Yeah, that's absolutely accurate.
Most definitely.
And based on what I just heard you say, it's also within our responsibility to ensure that we're monitoring that progress, correct?
I think I know what you're stating here. So I understand that you're wanting to monitor, but there's also 2019-3, which states that the Department of Education implements policies and procedures of the state board. That's one of our duties under statute, as well as the duty of conducting the analytical research on behalf of the state board in order for the state board to establish educational policy.
And recommend.
So
Go ahead.
ultimately, what the committee's ultimate goal here seems to be that they would be establishing some sort of educational policy in regard to turnaround academies. That would imply that we would be conducting the research as the statute prescribes to us in order for you to establish the educational policy.
Dan?
And the resolution calls for the department to provide us data. You could use the word research if you want. So really, I mean, with all due respect, I don't get your argument. But we could have Michelle address this. I guess are you contending that this board shouldn't study policies?
Not at all.
Probably
No.
And because that's what I hear you saying. But Michelle,
Not at
would you
all.
please comment on
Just
this?
so
Wait,
is,
wait.
Because this is our board attorney.
I understand. I just want to
Sorry.
clarify. I'm not saying that you
No,
shouldn't
not at
study
all.
the policy.
Thank you.
Not at
But
all.
the way that the statutes are written and the way that powers are prescribed, this implies, the motion implies and assumes that the board has authority that is statutorily designated to the Department of Education. So-
Your authority is?
Indiana Code 2019-3.
No, not the number, but the authority we're assuming?
In the resolution, so if I read the resolution, it says that board staff would be the main staff that would be with the committee.
Our staff, but we'll get data from the department. It
Well,
says that in the resolution.
Sure, it
Okay.
says that, but, you know.
And then I'd like Michelle to comment.
Well, just to kind of clarify, we're not saying that the board staff and the board can't conduct the research and analyze the research to establish anything. We're saying that's a statutorily prescribed duty to
Yeah.
the department, and this would be overstepping the authority that's statutorily implied to the board. And there's
we've
also
heard your
case law
answer.
that states that administrative agencies are entitled to presume that the actions of other administrative agencies are in accord with Indiana law. Otherwise, there would be wasteful duplication of effort in the work assigned to agencies. So what we're saying here is the creation of this resolution and the work that the resolution is saying that is already
Understand.
stuff that we at the department are prescribed to be doing.
But we want to oversee this policy that we implemented
And you
and
absolutely
review it. So
can.
Michelle, would you comment on this?
And the Center for Education and Career Innovation is not in statute to
Michelle, could you
actually
comment
do
on
these
that?
duties.
You absolutely can oversee. We're stating, though, that the work is conducted
Could
by
we
the
have
Department of
Michelle's input,
Absolutely.
please?
Absolutely.
Thank you.
Before Michelle speaks,
Wait
may I
just a
ask
minute.
a question?
Wait just a minute, because everybody goes through the chair. So Gordon,
I please
you may.
speak? Thank you.
You may.
Is there anywhere in state law that says that the State Board of Education is not permitted to do something along the lines of this resolution?
So you can create a resolution. I don't think there's anything that doesn't say you're restricted from that, but this resolution, in our interpretation, implies that the board has powers that we don't see that it is explicitly prescribed in statute. And we did find, as I read earlier, some case law to support the fact that the Indiana courts have determined that you can't imply powers to exist. You can only exert powers that are explicitly prescribed in statute.
I was hoping that we could postpone this until August so that we could work out the language to be agreeable between the two parties. That's actually my hope, that we would be able to do that. There's a disagreement as to who has authority and power regarding the staffing of this committee. I am in total agreement. We need a committee. We need to look at this work. We need to study it. I'm not asking to be on it. This is a matter of CC actually being given authority that they have no statutorily right to do. In addition to, that would be duplicating the services that are already afforded to the Department of Education. Did I say that right?
So really
Maggie?
the only issue is
That's my only issue.
CC staffing
That is
this.
correct.
Okay.
Correct.
So the resolution says that board members will be on it. And so we can create
Oh,
our own subcommittee. So
I'm not questioning our
objection
procedures.
isn't that we have a
No,
subgroup
not at all.
of the board.
Not at
It's
all.
the involvement of that group.
It's how it's
The-
how it's been written and executed in terms of who's providing the services to the committee.
But the resolution doesn't prohibit you from, at the department, from providing guidance to us and recommendations. Is that correct? I'm asking the department staff.
Maggie.
No, it doesn't, but I think that there is some ambiguity in regard to the language that is.
So they're not taking the place of the department, they're providing additional information, such as when we get input from teachers and principals and constituents and so forth, we get input from a variety of sources. And secondly, I think I'd like to have this for our next agenda, Bob, if possible. I'm getting confused about different attorneys appearing on our behalf. I believe this is the State Board of Education, and I'm not sure the legal authority of having a Department of Education attorney appear before us. And so I would like to put that on our next agenda. I feel that we have a State Board of Education attorney that represents us, and I'm still misunderstanding the legal authority, how a Department of Ed person can come up and give us legal opinions. We should have one attorney versus two attorneys standing at a podium arguing. And I would like to hear from Michelle, our State Board of Education attorney.
Just to clarify, I did come and say I was representing the superintendent of public instruction in the department's stance and defending the department, and I was recognized by the chair. I just wanted to clarify that I am not acknowledging that I am board staff whatsoever. I'm just trying to acknowledge that we see some issues with the way that the resolution is written, and frankly, I think there is just some confusion in who is the staff authority here and
Right.
the work to be done and who it's assigned to.
Right, but there's no question who the State Board of Education's attorney is, Chief Legal Counsel.
No, I never questioned that.
And so by having this dual competing attorney that we've gone through for an entire year now, I'd like to get that resolved at the next meeting. And I think if the department attorneys have some issues, they can certainly consult our attorney. But to have a debate like we've had for an entire year, frankly, it's getting a little tiring. And I would hope that on this issue, if there's a legal issue, we can vote on it. We can vote on the resolution, and if someone feels that it's inappropriate, anyone from the public or anyone else on the board, they can then send it forward to the Attorney General's office or whatever, but it should not stop the process of this board. We have a right to vote on a resolution. Let's vote on the resolution, and if there's some question about its legality, then that can be taken off as a second step. But it's been used in the past to stop our progress, and it's delaying what we need to do. So I would urge us that we go ahead, vote on the resolution, And if there's some problem with it, then that can be taken up at a different point in time.
Michelle, you may address.
Sure, thank you. I know that we all want to be clear about roles and responsibilities, but I do, in terms of the case law that was cited, I do want to just point the board's attention to one of the prior resolutions that came up in the fall where a similar argument was made, and we did get an Attorney General advisory opinion that talks about the way to interpret the broad legal authority that the General Assembly has granted to the State Board of Education. I want to cite just a couple of specific statutes. 2031-9-4B puts responsibility on the State Board of Education to determine whether an intervention would provide school improvement and gives the board the authority to assign the appropriate intervention. 2031-9.5-7 provides that the contract, in fact it came up earlier that there's a contract with the department and turnaround school operators, but by statute that resides with the board. It's just that back in 2012 the board didn't have its own staff, so the department entered into that contract on behalf of the state board. Under 2031-9.5-5, it gives the board the authority to determine whether a mayor who has petitioned for oversight responsibility of a turnaround academy, the board has the authority under that statute to determine whether that's appropriate and in the best interest of the students. So I just want to be clear, when I look at this petition, you know, it mentions staffed by the Center for Education and Career Innovation. I am both CECI staff as well as the State Board of Education General Counsel. This was moved, the staffing for the State Board of Education was moved by the General Assembly under the executive. It has language about having this group of folks do research, review, and analysis of school turnaround best practices, analyzing progress made by turnaround academies, and developing lessons that have been learned to date. Benchmarking for turnaround best practices. Again, utilizing lessons learned from past and present interventions. Provide, project, and recommend future staffing support for turnaround oversight, and providing a report to the board by November 2014. I can't imagine any argument that would prohibit the board from having its staff, in partnership with the department, do this kind of research and analysis, given the incredible responsibility that's placed with the board as a legal matter to assign interventions and make modifications. As you know, SEA 205 was passed this year, where within 5 years the board has to decide what it's going to do with these turnaround academies. And finally, I want to know, under 2019-3-4, that is a statute that is a duty for the department. It says that the department shall implement the policies of the board and shall conduct research that's requested by the board. But that is in no way, shape, or form an exclusive responsibility, and I think that it would really be a disservice to the board to say it could only look at research that's performed by the department. I think that that's the idea, that the department's there to implement policy as well as conduct research on behalf of the board. So I do disagree that this in any way contravenes state law. I think it, you know, as a legal matter, I think it's appropriate, and as a policy matter, I think that it's good. And again, it specifically provides for and requires partnership with the department. So it's, again, requiring the collaboration that we would like to see.
Michelle, is there a reason why this resolution is different than the ones we've had before? The ones that we've had before have always stated the State Board of Education staff. This one now says CC. To us at the department, CC is an agency formed by the governor. The State Board of Ed staff is the State Board of Ed staff. And we see them as two separate entities, and you may have been hired under that agency, but when we expand this to be talking about the agency, that agency does not have authorities under statute as the Department of Education does.
So if I could
am
respond,
I clear?
If I could respond
on that?
The entire purpose of CECI was that you have these 4 different bodies that are recognized under statute that all deal with education and careers, and it was for resource sharing. So I would certainly hope that if I could talk to Marie McIntosh or Nate Klink from the Works Council or Career Council, if they can point me to relevant research that might be helpful. That's the entire purpose of this, and we're allowed to do resource sharing, and I think that that's helpful. The more expertise, the better. So I think that this was drafted in a way that both would allow me to use my own research abilities as well as tap into the other folks at my CCI or agency.
Who you tap into,
I'd like to make a comment.
in a moment, who you tap into is who you work with, or however that happens. But to actually give it explicit authority within this resolution is a whole different matter. And so that's the issue. And was hoping that we could just resolve it. We've been saying the State Board of Ed staff in these resolutions time after time after time after time. This is the first time that I recall that we're actually mentioning CC as having the total capabilities of actually doing this work. And that's the issue.
Sure, and
So are
again,
you opposed to putting State Board of Ed staff in here as opposed to CC?
I mean, personally, I think that to the extent that we can, again, you do resource sharing, as you know, there's James Betley has been working on pre-K. I mean, to the
We
extent
do
that we have
resource
folks that
sharing
have research.
everywhere,
And I
Michelle.
don't think that the board is precluded from putting in a resolution that it's going to use research from anyone. It could use research from Cell or Keep, all different kinds of
Are you
entities that
opposed
don't
to
have
putting
statutory.
State Board of Ed staff
Well,
in
that
there?
would really be for the board.
It's up to you all.
Well, she wrote it.
Yeah.
I will draft this
Did
or modify
did you
this.
draft this?
Are
I
we gonna
personally
recognize?
did not draft this.
Who
Brad,
did?
Are we gonna recognize Brad?
I
In a
don't know who
moment.
did. I think perhaps Brian Murphy or Claire, one of our attorneys. I did look at it, and again, as always, as the general counsel of the board, look at it to determine if I thought that it was statutorily compliant. Again, as I just shared, I think that it is. I am happy to substitute State Board of Education staff if that's the overall will of the board. It can remain CCI staff. As I said, I sort of serve a dual function, and I don't think that that was, you know, intended to do any harm.
And that's my point. I don't think and that's why I wanted to have a conversation between the two groups, because I didn't think that was anybody's intent to be doing that. So Maggie, I want to ask you a question. If we switch this to the State Board of Education, State Board of Ed staff, do we have a legal issue then? No, okay. So if you're willing to do that, I hope that's the wish of the board as well. It's a technical
Brad's
issue,
trying to
I'm aware. I'm aware it's a
acknowledge.
technicality.
I think it's much
In
ado about
terms
not.
of-
Yeah, this is.
So it
much ado
shouldn't,
about
it
anything.
shouldn't.
I don't
Can
care.
Brad
It
be
shouldn't be an issue at
recognized?
all.
Brad Oliver?
Brad, wait, Dan, I'm the chair.
I know, but he's.
Brad, are you still there?
I am. I've been waiting patiently. Thank you. I would just say this. I am concerned that why it is repeatedly just has to be worked out between attorneys in front of the board in the public meeting. This resolution was on the agenda. There's been plenty of time to have a debate about what each side's interpretation of the law. The bottom line is that the state board has a vested interest in the children served by these school turnarounds. The board is interested in making sure that we're doing it well. I would encourage my colleagues to let's move on this. We're voting up or down on this resolution. I think this work needs to be done. It's critical to what we're trying to do to help kids. This legal debate stuff, I'm getting tired of it. Frankly, can be worked away from the meeting and worked out. I'm not trying to take away from the concerns being expressed, but it's not central or germane to the overall issue, which is we have a board that is deeply concerned about our students, and we need the capacity to do some work, and sometimes that work happens in a subcommittee. I would also just remind the board, too, and my colleagues, when we get into interpretation of statute, we've had this happen before. There's precedent in the past where there's been a track record in the past where department counsel has not been right. We had a resolution in November where they weren't right. So I would just say this. I think my colleague David Freitas had it right. We take care of the resolution in front of us. We have a right to vote it up or down. If there is a legal question about it, there are ways to resolve it outside of this meeting. But I want to stay focused on students.
Troy?
You know, I just think that being the first time really that I saw it was when the agenda came out, that I'm not opposed to tabling it and getting time, because I'm still in the situation where I see a lot of things, just like the previous discussion that lasted over an hour. You know, poor playing on somebody's part doesn't constitute an emergency on mine. And I hate to say that, but at this point, you know, we do have time where we could get school started and then do this research and be okay. It's not like it's a pressing thing that has to be done right now.
Superintendent?
Dan?
I want to move on this. It'll take me 2 seconds. I want to be clear to everybody listening in the spirit this is offered. Be it further resolved that the committee shall be staffed by the Center for education, career innovation, which shall in turn partner with the staff, the Indiana Department of Education, and it goes on. There was never this is very simple. The board has a staff. This has been a board issue. It's not an emergency. That's precisely why I want to move, Troy. We need to analyze and learn. Just that last discussion made it really clear. We ought to really learn about what we do, policy, how to improve it. Are the recommendations for the legislature we'll want to have ready in January? It's a very simple, straightforward, wholesome, proper thing for a board to do, and we ought to move forward. It was never intended to go off alone. It was in partnership. I think it was written very well, frankly.
And I have a
So
simple
thank you.
request to have it say State Board of Ed staff. It's very simple. I mean, that's who staffs you. That's who staffs us.
Madam Superintendent, may I
Yes.
just comment briefly? Again, just to comment on this, I think it is much ado about nothing, and it is semantics. The State Board of Education staff work for CC. I mean, that's just, you send an email to them, cc.in.gov. I would have no problem changing it to State Board of Education staff, but I don't think that changes anything. So, I mean, we all agree, it seems, that what we're talking about is important, and we want to see it move forward. So,
And I agree.
I mean, I think everyone in this room recognizes your position about CC, but I don't think we should get hung up. Let's just move forward. If someone who wants to propose an amendment to amend the language, then somebody should do that.
I will do that. I move that we amend to say State Board of Education staff where it says CC. And do I have a second?
Second.
Any more discussion? David?
It's already implied in everything we do. We work in collaboration. And so by making a huge point about it now does not make sense to me. It's how we've been operating in collaboration. So I'm going to vote no on the amendment.
This is the part of these meetings that I hate. It's unnecessary tension. My stomach starts churning the night before. I seconded the motion because the wording would be accurate. We want the State Board of Education staff to partner with the DOE staff in supplying this committee with what it needs to do its jobs. And I think for the purpose of moving this issue along, the motion makes a lot of sense.
So we'll go ahead and move on the amendment. Roll, please.
Mr. Elder?
Yes.
Mr. Elster?
No.
Dr. Freitas?
No.
Mr. Hendry?
Yes.
Ms. Neal?
Yes.
Mrs. O'Brien?
No.
Dr. Oliver?
No.
Mr. Walker?
I think he's left.
No.
Oh, no, he's there.
Mr. Watts?
No.
Superintendent Fritz?
Yes. The vote? Vote on the amendment?
I'm sorry, I apologize. 4 yeas, 6 noes.
Someone missing.
We're back to the main motion.
Did we count the votes? Was there somebody missing?
Yeah,
6
Carrie.
to 4.
Carrie.
Carrie's not
Oh,
here.
I'm sorry.
Madam Chair,
Second.
I'd like to move the resolution as is.
Second.
I thought we did move it.
That was
Did
the
we not
amendment.
I
move
think we
it?
just need to call, I called.
We
vote.
moved it, we had the second, we've
Okay.
had amendment, we've had all that. So now we call the vote.
Mr. Albert?
I'm going to vote no. I wish to table it.
Mr. Elster?
Yes.
Dr. Freitas?
Yes.
Mr. Hendry?
Yes.
Ms. Neal?
Yes.
Mrs. O'Brien?
Yes.
Dr. Oliver?
Yes.
Mr. Walker?
Yes.
Mr. Watts?
Yes.
Superintendent Fritz?
No. I want to clarify that I'm not voting against the concept of actually having the committee and actually doing the work. I've already made my objections as to what I wanted to see changed in the resolution. The next item of business is the approval of the strategic plan. Dan?
May I speak to it just briefly? As you know, some time ago, this board approved a strategic planning effort for education in Indiana. This would be a plan that we look for partnership, all involved, other state agencies, school districts, schools, teachers, principals, parents certainly, this board and all involved. It has a very clear vision of where we want to go, a mission and 3 clear goals. We expect as we move forward as a board to make this a living strategic plan, and it's living in a couple ways. We'll continue to review it to see how we update and improve, but we would also translate it into annual budgets, where the resources of the department goes, where the priorities go, where the personnel go, what kind of personnel we need to pull it off. So the board would be responsible for seeing that the efforts are aligned. It's reflected in annual budgets and how we assess our progress. I appreciate greatly the committee that worked so very hard. We were successful, and the firm we hired, CELT, to help us do the plan. It's done in the right framework, and now with our dedication and focus, we can make this the vision of where we're going and the roadmap how to travel there with an openness to innovation, creativity, and follow through, so that the staff and the resources, bless you, whoever sneezed, I'm getting ready to myself. And so I think it's a wonderful piece of work. I do thank the colleagues that worked on it and the many people who gave us such generous efforts to bring it together and comment. So you saw it in your packet. It's there for us to adopt today. So with that, I move we approve.
Second.
Discussion? I do want to make a comment whereby I agree with the mission and the goals of this strategic plan. I do feel that many of the strategies within this document simply represent an attempt by the board to just oversee and monitor the department and local school corporations, and that's not something that I feel comfortable with. And your comments, Dan, that you just made just reiterates exactly what I just said in terms of making sure that my personnel are available to do what this plan is wanting to do, reordering my budget to do what this plan is doing. That is not the intent of this strategic plan. And so I just simply say that while I had a lot of input and appreciated working on the mission and the goals of this strategic plan, and whereby I agree with many of the things that are in it, there are many things in there that are simply wanting more oversight over the department and how I run the actual Department of Education. So with that, I just want to make that comment.
May I comment?
You may, Dan.
Thank you.
I have a quick comment.
Yeah, I'll finish real quick, Brad. I'll just, executives and boards around the country, this is a mammoth enterprise, a multi-billion-dollar enterprise, K-12 education. Human resource development in the state is probably the critical factor in the future of the kind of society, culture, and economy which we'll live. So having this as a joint effort, and with all due respect, it's not your budget and it's not your staff, it's the state's. The state's invested in education so we can go a direction together that's good for young people. It isn't dividing up, this is mine and that's theirs. It's trying to get everybody aligned in a direction that makes a big difference for children. And this plan, really what it speaks to then is how do you work with higher ed, how do you work with workforce, how do you work with districts so we're aligned and go in a direction we can join hand and make a difference. So frankly, I never heard anybody in the discussion talk about me, mine, yours. It was about we. Where can we go together? That's a powerful vision, a positive vision, and I appreciate the input. And if you took it that way, yeah, I'm sorry, because it was never intended like that. It's about pulling together one direction for the benefit of the young people and the future of our state.
Brad?
I just was going to say, I I appreciate so much the involvement of multiple stakeholders that went into, their input went into the development of this plan. I think the strategic plan is probably one of the most important things this board can do in fulfilling our statutory obligations. And I just wanted to make two comments. One is that it is a living document, and for that reason, I hope the board will revisit it regularly, including keeping track of the metrics, both leading and lagging indicators that are associated with the plan. And second, I do hope we continue to move forward with the integration of our plan with other plans, so we do have the kind of coordination that Mr. Elsner just talked about. Thank you.
And Brad, I would comment that because it is a living document, that we get to the point where it doesn't feel nor look nor read like the Department of that the State Board of Education is actually overseeing the department's work, and that we do work jointly in moving forward with some things rather than having what I consider to be more of a monitoring approach to working with the State Board of Ed.
I too want to thank all the stakeholders. Many people were involved in the process. And I have a question either for Dan or maybe one of our staff people about next steps. We talk about having a living document, but also we've created a balanced scorecard within a strategic planning document. And so could someone speak to what are the next steps to actually get this strategic plan operationalized?
I'm sorry, I should have mentioned that from the very beginning, CELT was clear. They are very steeped in best practice, not only education, but other kind of enterprises. And we will have to have a committee of the board, possibly one that created it, we'll have to talk about that would oversee implementation. Keep the focus on it. Keep, again, marshaling efforts, pulling, so we're not going a little bit this, a little bit that way. So I should have mentioned that in my opening remarks. Many strategic plans are built, a few are followed and pursued with vigor and focus. And if you want it followed with vigor and focus, you have to have a committee of the board that goes back to it, looks at annual budgets, looks at allocation of personnel, looks at communication priorities and say, where can we go together? So I would recommend that as we move forward, we have an ongoing committee that keeps this alive in front of us for refinements, addresses concerns, expands, and keeps that kind of focus.
Do you envision another committee being formed, or will the strategic planning committee continue to be that operationalized group?
Yeah, I would, obviously the board has to decide that. There might be some benefits because we worked hard on it, and whoever wants to chair it, I'm fine. I was glad to serve, but at some point, I think we ought to probably formalize that committee. Some folks that helped in developing it would probably be wise, and to monitor, especially out of the gate, and then you could rotate members. So that would probably be a very wise decision. And at some point, I don't have a formal resolution on that, but maybe we ought to do that next meeting.
Definitely.
And we could consult with superintendent certainly and see who she thinks should be on that and work together to make sure it comes alive.
Yeah, I would hope that at the next meeting we would have a resolution or a motion to either appoint people or continuing the current group with maybe some additional people added. I want to be sure we don't lose it. There's a lot of good concepts in here, and a lot of people worked on it, and so it's important to get it implemented.
And as that resolution's built, please have staff and superintendent's input so we're aligned and in partnership on this plan.
Andrea?
Yeah, I'm going to vote for the strategic plan because I like most of what's in it. I just wanted to express I get anxious when I hear words like human resource development or read language like maximizing the potential of human talent. I always like to remember that the purpose of K-12 education is to impart knowledge, to create active, informed citizens, to develop civic virtue, and not to serve as a talent development agency for future employers.
Any more discussion?
Call the question.
Roll call, please.
Yes.
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 Civic planning, character. I agree with you.
Yes.
Yes.
Yes. Next item of business is the resolution regarding ESEA waiver. We have some speakers. The first speaker is Dr. Vic Smith. Thank you for your patience.
Thank you, Superintendent Ritz and members of the board. It's been a long day. I appreciate this chance to talk with you. I rise during public comments to appeal to the State Board to stay true to House Enrolled Act 1427, to measure growth by criterion reference measures and not by comparing growth to that of other students. This resolution supports and extends the use of growth compared with peers, and so I oppose this resolution. I listened closely to your discussion on Indiana growth models this morning, and I learned and updated myself in what has been said. And what I've concluded from that earlier discussion today is that the clock ran out and we had to tell the federal government what Indiana was going to do, and so we decided to do what we've done before. I find that to be very unfortunate. House Enrolled Act 1427 was passed by the General Assembly in 2013, saying that the A through F system in Indiana, quote, may not be based on a measurement of student performance or growth compared with peers. This culminated a 3-year effort to fix the flawed A through F system by rejecting the use of bell curve statistics in assessing student growth and by measuring the growth of students against fixed criteria. HEA 1427 further says that 511 IAC 6.2-6, which is the rule that has all of this in it, is void on the effective date of the emergency or final rules adopted under this section. So this resolution before you breathes extra life into metrics that judge growth compared with peers. It also says that that rule, 511 IAC 6.26, shall be followed by the A through F accountability system. That's the very section the General Assembly voted 15 months ago to void as soon as possible. So what's wrong with peer-based statistics? They lead to amazing and unpredictable results about low growth and high growth students, especially for many highly talented students who consistently scored well, but somehow got pegged as low growth and become a detriment to the school. The ultimate example of this concern came when one superintendent and principal documented a student who got perfect scores 2 years in a row, but was marked as low growth by these metrics. In short, Hoosiers have lost confidence in the credibility of these peer-based growth metrics. Now, Dr. Batenbenner's report to the board about growth models listed 5 options. He stated that option number 3 is a feasible option which the state board might adopt. It is a criterion referenced option and does not rely on student growth percentiles, which are peer comparison measures and which have been readopted for next year, sadly. I hope the board will take a deeper look at option 3 in his report. And so I urge you to withdraw this resolution due to the way it addresses student growth, and I thank you for listening.
Thank you, Vic. Next speaker on this item is Gail Zahairlis.
Good afternoon. I'm Gail Zahairlis with the Indiana State Teachers Association, and BJ, I know it's been 6 hours since you had your opening statement, and I certainly want to take into account what your thoughts were and all that, but I also want to argue that the ISTA, in communicating with its members on some of these resolutions today, albeit mostly on the next one, we took it very seriously, and I believe pretty darn responsible in how we did it. Because frankly, it's summertime, and our members have just come off of their national conference, and if we'd have said, everybody, come down to Indianapolis this morning and be here and show up, they'd have come. I ask you to look at our social media, our communications, and understand that what we were doing was advocating involvement and understanding of what goes on here, and to do it in an organized way. First, to communicate to you all. When your email box is filled up, many of you, we asked them to communicate with their legislators, with their school board members, with their neighbors and friends. That's the American way. And I certainly didn't expect thanks for trying to be responsible, but I want to make that point, that I believe we were very responsible in how we communicated these messages, which have to do with very important things. And I know that you've seen enough lawyers in the last year here. I happen as well to be a lawyer, and so I kind of look at things in terms of arguments and how to make them and make my cases. And I could argue that a couple of these resolutions are political in nature themselves and not about children. It doesn't take a lot of dots to throw up to connect to that. And so I could do that, and I could remind everyone that this State Board of Ed called an emergency meeting in May to talk about the waiver resubmission, and took about 2 hours to allow the DOE to talk to you about it inside that meeting. And I could argue that we're here 2 months later with a resolution that seems to want to talk more about discrediting the DOE than to allow the DOE to do its work. And I will remind everybody that at the end of the day, the department is charged with the waiver resubmission and will be responsible for its implementation. The buck will stop with the department. Now, that doesn't mean this board doesn't have a role. Please don't misunderstand me. But nobody in that State House over the last year felt that we were going to have some waiver issues based upon what was done. And so what the DOE has gone about to try to do in a very short timeline is do its work. I began my few minutes here sharing that I'm a lawyer, and honestly, when I saw this particular resolution with its tone, and then when I learned that there was a report sent to the US DOE overnight or within the last day or so, the first thing that came to my mind as a lawyer was the doctrine of tortious interference with contracts. I mean, here, this department is trying to do its work, and if you have, you know, a reason to think that it's not being done in good faith, that's an issue. But I don't think that's the issue this resolution calls for. And so, from the ISTA's perspective, and what we wanted our members to understand here, is that we believe that this resolution is unnecessary and ill-timed, could be dangerous to the ultimate outcome, and we believe we're all bigger than this. You know, this looked petty and small and a bit political. And so, from our perspective, if that's a half-truth in your eyes, I am telling you that is how it looks to many people in the public. And we believe it's our obligation to talk to our members about it. Thank you.
Thank you very much. The next person to I think those are the only two on this matter. So I need a motion to adopt the resolution. Brad, do you have a motion to adopt your resolution?
Yes, so moved.
Is there a second?
A second.
Brad, I've got some concerns that this resolution may be out of order. So can you explain to me the specific statutory authority for this resolution? Brad?
Yeah, I'm having a little bit of connection there, but I can hear you now. I don't know if the microphone can be pulled closer or not.
The question is that I have questions regarding the statutory authority and for this resolution and may be out of order. So could you explain to me the statutory authority for this resolution?
If you could help me understand, because this is the first you're sharing that with me, I'm not sure what exactly the concern is.
The concern is, what is the statutory authority for the board to carry out this resolution?
Well, I guess I'm looking for more specificity with regard to what specifically in the resolution is of concern. The resolution basically is intended to acknowledge that the board has statutory obligations related to various things that are included in the waiver that was submitted to the federal government. And it's simply basically asking for a few things. Among those is making sure that any additional amendments and finalizing our waiver be congruent with Indiana statute, to make certain that anything related to the issues of assessment or accountability where the board would have statutory responsibilities, that the board has an opportunity to weigh in. So unless there's something more specific, I don't know how to respond.
This resolution?
The state board voted to pursue the waiver. The state board voted on the waiver. It's the state board's waiver. That's the authority.
Tony, the board took no action on this waiver, ever, even in the initial submission, and played no part in that at all. So, which is why the department has taken on the sole responsibility and is taking on the sole responsibility as the state education agency for the submission of this waiver. And so that's where it is.
Madam Chairwoman, I don't hear anything, or I don't understand, I don't see anything in the resolution that would interfere with the department moving forward. You've done that. I think the concern that's been expressed by the board repeatedly is wanting to be kept informed, particularly with regard to things that do clearly fall into the camp of the board's statutory responsibilities. I don't see any conflict here, but I'm also not hearing you mention anything specific in the resolution itself, other than just in general you don't like the resolution.
No, I have several concerns regarding each one of these pieces. So I have asked my general counsel to address the issues that we do have, because they're a grave concern to me, and I'll make my comment regarding that a little bit later.
I don't think we should hear from the counsel for the Department
I have
of
asked my
Education.
counsel to come and address, and Brad has asked what my specific concerns are.
While they're coming, can I just say, I don't understand why we wait to the meetings to have them. These concerns, this resolution has been submitted some time ago, other than doing it in the public forum, which is fine, but I don't understand why there can't be, if there truly are these genuine concerns, even though we would deliberate them in public, why there's not issues raised before. I feel like this is not productive to have counsel, because the department counsel is going to get up, and then board counsel is going to get up, and this does affect students. It affects students in the sense that the board has a responsibility to make certain that the things that are happening in our state conform with ed policies set by this body. And that's the differentiation. I mean, 2019-2 clearly spells out that the State Board of Education is responsible for every aspect of ed policy, while 2019-1 and 2019-3 spell out the responsibilities of the superintendent and the department with regard to carrying out those policies. So I'm still not hearing anything that says that there's anything in this resolution that would interfere with the department's responsibility to make sure that they keep everything congruent with current Indiana statute and consistent with the policy set forward by this body.
So I'll proceed. What statutes or Indiana Administrative Code sections were not complied with in Indiana's waiver renewal application? And what evidence do you have to support this belief? Because you have stated in this resolution that obviously I have not done this.
So if I'm hearing you right, you're raising a concern concern over an interpretation that the department or yourself has over the resolution, and I guess all I'm simply saying is that I don't know that we're going to resolve differences of interpretation over statute. The question is whether or not a board member can bring a resolution, have it deliberated, and then vote up or down on it.
I'm trying to determine if this resolution is out of order. So I'm questioning the items that are in here. They are clearly here to say that the department has not done these things. And as a result, this resolution has been brought forth to have the department comply with the items that you have written in here. So what statutes of Indiana Administrative Code sections were not complied with in Indiana's waiver renewal application? I am not aware of any. I've not heard of any, and yet that's in this resolution. What authority?
Well, I will defer to board counsel who's able to speak to this, because obviously we've had them review the resolution. It always bothers me when a suggestion is made, and this is not the first time that's been suggested, that somehow a resolution that's been drafted is not congruent with Indiana statute. And we've seen in the past where that's happened, gone to the Attorney General and found out that in fact it is. So I would just ask board counsel to weigh in on specifically the fact they have reviewed this resolution. It is in keeping and congruent with Indiana statute. In fact, it's actually asking that everything we do with the waiver stay that way.
Michelle McGowan, one question. What statutes or Indiana Administrative Code sections were not complied with in Indiana's waiver renewal application? Are there any?
Well, while they're coming forward with that, let me just also add that there's no statute saying that DOE has responsibility for this. So then what?
It's between
The state of Indiana's waiver, though.
the submission.
Body would be the state board. There's definitely no statutory authority saying DOE has the authority over federal waivers.
I don't see any language.
They're actually, let's have that addressed. I'll address that in a minute, Tony.
Madam Superintendent, your question presumes language is not in the resolution. I guess I'm trying to understand where it says in here that Indiana's waiver submission has violated law. It doesn't. Can you point that out to me? I mean, am I
And I
missing
can
it?
clarify, because of our board operating procedures, the resolution had to be distributed last Tuesday. The waiver wasn't submitted in full form until about 4:30 on Monday afternoon, the 30th, the day before. There wasn't time for the board to review the full and complete submission. And this was merely establishing guardrails. It does not at all imply or state directly that there was any violation in the statute. It was establishing guardrails
Guardrails for what?
for the waiver submission.
The waiver submission, it's been submitted.
Yep.
It's been submitted.
Yes, but amendments can be submitted if there is something that is within the waiver that does not comply with board policy.
So if it's been submitted, then, and these things have already been adhered to, what is the purpose of this resolution?
Go ahead.
Brad, what is the purpose of this resolution if the waiver's been submitted and all of these things have been adhered to?
Well, Madam Superintendent, with all due respect, I believe the board is absolutely within its purview to set some boundaries with regard to policy parameters related to this waiver. The board has been concerned about the waiver for some time, and with all due respect, I saw the press release yesterday where the comment was made that somehow this resolution would jeopardize the approval of the waiver. I would argue that when we had the monitoring visit and 9 of 18 assurance areas were found non-compliant, it was already jeopardized. My interest as a board member, state board member, is asking my colleagues to help basically set some parameters so that as we move forward, there is a clear understanding from the board to the department that to the extent that items in the waiver or any additional conversations related to amendments needed to preserve the waiver that relate to areas in which the board has statutory responsibilities, there would be some discussion within the board and approval by the board before any commitments are made. I'm growing very concerned, particularly when I hear about things such as the department signing contracts with CTV McGraw-Hill for an assessment, which I hope we talk about in a little bit. When those kind of things happen, it makes these kind of resolutions necessary. I don't believe there's anything in there that is out of order. I understand you have a different interpretation. I'm simply asking for the opportunity for my colleagues on the board to vote up or down on the resolution.
The waiver has been submitted, and this entire resolution specifically says and directs the department, Indiana's complete waiver renewal submission shall comply with Indiana statute and State Board of Ed regulations. And it goes on and on and on and on.
What's debatable about that?
It's been submitted,
We
and this
follow the
board,
law.
this board contends that you did not have input into this waiver. This is, just this top part are the internal emails that went on between the State Board of Ed staff and all the other entities involved in this waiver submission. There has been transparency about this waiver from the very beginning. We've done presentations upon presentations upon presentations, and when you ask for, you didn't receive the final copy in time to review it, to once again inform, I want to remind the board members that I don't recall getting a lot of input regarding this waiver. Not only, I don't know if you received these.
I can answer that.
I don't know if you received all these. You can't see what I've got here, Brad, but I've got attachments upon attachments upon attachments and emails upon emails upon emails where we have worked with your staff, the State Board of Ed staff, over and over and over and over again. And I might also say that the State Board of Ed legal staff, Michelle McGowan, was present at all of these entities. And so to intimate that we have not submitted a waiver that's in compliance with the items that are in here is simply unnecessary. It is an attempt solely to say that my department is not doing its job. It's actually insulting. With the board committing their support, they committed their support right at the start to extend this waiver. The board staff had 2 months to give input into the submission of the waiver. You've had access to the original waiver for as long as you've been on the board and it's been in existence. And so we have asked for input, we have provided input, we have had numerous phone calls, we've had everything that we need to have to actually inform the writing of the waiver. My department is used to the Governor's Education Agency interfering actually with our daily work. I was not surprised at all that they submitted their critique of the waiver to the U.S. Department of Education. Didn't surprise me in the least. I am used to critiquing by the CC on a daily basis. Politics and discrediting me and the department is more important to them than extending this waiver into Indiana's children, potentially causing harm to service being provided to the students in our schools. When you actively, as a board, condone the CC to do a review and a critique and send it to the U.S. Department of Ed, no matter what it says, no matter what's in there, to me, that's what's happening here. We made a joint commitment to this waiver, and yet the only thing that I've gotten from this board is process, 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 process. And the real piece that needed to happen was content, 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 content. So all I can say, Brad, is that we had a responsibility. We had a lot of, this stack right here that I've got in front of me doesn't compare to the stack that we sent to the U.S. Department of Education. On a very short timeline, we had to turn around 300 and some pages of a waiver, as well as over 100 attachments. And for this board to say that they did not have input and did not have involvement in this process is completely false. So
Well, I will interject here because I want to speak to that point because you're making a statement in light of facts that basically indicate that we had a visit in August. There was an interview exit in September. It is now known that USDOE has confirmed that as early as December, the chair was aware that the condition was going to be placed in a waiver. We didn't find out until April the 25th. We asked immediately for a special meeting around May the 2nd when we were finally provided evidence in the monitoring report by a news reporter, I might add, not the department itself. We finally got a meeting on the 13th. We went more than 60 days. We could have had more than 60 days. We didn't, for whatever reason, didn't engage USDOE immediately. But within the last 60 days, yes, career people at the department have worked extremely hard, and I think I've been in more than one public setting have said just as much that how much I appreciate the hard work they've done. I will argue the extent to which board input was sought was limited. We received drafts literally less than the 5 business days coming into the special meeting on June 23rd, and we finally received a copy of the full waiver for the first time with all of the appendices at the same time that the press release went out on late afternoon of June 30th. So if I'm being unreasonable, simply asking for a resolution just clarifies that to the extent that the board has responsibilities, just as the department wants to carry out its responsibilities, I take my role as a state board member. And the fact that we've been appointed by the governor really doesn't matter because the section under the statute says the board is responsible for policy, and the governor is also an elected official who has responsibilities to the students of this state as well. And we need to work together. I don't think you can mention anything specific in the resolution that is not congruent with Indiana statute. I know you have objections on the resolution just simply because you're taking a personal front to it. Somehow it infers the staff did not work hard or didn't do a good job, and that's certainly not the case. It is simply saying that there were things that the board would have liked to express itself on. It's not been able to do that. We tried to introduce a resolution on the 23rd. It was blocked on that day. We're bringing it back, following the meeting procedures, and I'm simply saying I don't see anything there. I don't know why the board would not be allowed to vote up or down on a resolution.
So I'm going to go ahead and state my position and ask these questions regarding each of these items. So Indiana's complete waiver renewal submission shall comply with Indiana statute and State Board of Ed regulations. I'm going to ask them openly. I don't really expect to have a response, but I'm going to have them on the record. What statutes and Indiana Administrative Code sections were not complied with in Indiana's waiver renewal application, and what evidence do you have to support this belief? And what authority does the state legislature given the board to enforce this portion of the resolution? Next item. Any substantive waiver amendment requested to USEOD, apart from the requested amendment to reflect the new Indiana Academic Standards 2014 and aligned state assessment is not developed through the National Testing Consortium, shall be approved in advance by the SBOE. What authority does the state legislature given the board to require advanced approval of any substantive waiver amendments? Next item. Per SBOE Regulation 511 IAC 6-2-6 shall be followed for the A to F accountability system for federal and state accountability purposes. So per SBOE regulations, the department department's work shall comply with SBOE regulations. Teacher and principal evaluations shall continue to be governed by the code, and any proposals to modify the model plan, RISE 2.0, or to modify state guidance to school corporations or schools that have adopted a locally developed model must receive advance notice by the SBOE. The code requires the board to work with the department to develop a model plan and release it to school corporations. Done. What authority does the board have to require per approval of a model plan? Next item. Per code states that a school corporation may adopt the department's model plan or any other model plan approved by the department without the state board's approval. How does the board have the authority to mandate per approval by the board to locally develop plans? Next item. Information currently posted on the IDOE website regarding guidance to diminish the weight of I-STEP and growth calculations, RISE .25 memo, must be removed immediately, as this guidance was never approved by the SBOE, was expressly prohibited by the SBOE in the fall 2013, does not comply with the state statute or regulation, and does not comply with Indiana's ESEA waiver principles. What authority does the board have to order the department to remove guidance from its website regarding a model plan developed by the department? Next item. Given the incorrect guidance of RISE provided by IDOE to schools in 2013, as well as the confusion that was resulted from RISE 2.5 memo being posted at the DOE website, almost 1 year, IDOE shall send repeated communications to Indiana educators through the DOE dialogue for the months of July and August regarding the need to utilize RISE 2.0 or locally adopted model that complies in full with code in order to comply with federal and state requirements. What authority does the board have to order the department to do this? Next item. Assuming Indiana's waiver is renewed for 1 year, the IDOE shall provide monthly written and oral updates to the SBOE at regular business intervals, meetings regarding specific areas of waiver implementation, and SBOE staff shall participate in any formal waiver monitoring meetings or formal waiver monitoring phone calls with USED regarding Indiana's waiver implementation, performance, and compliance. What authority does the board have to order the department to do this? Now, I have committed openly every time to give an update onto this board regarding this waiver. It is not a secret. There's nothing a secret in that waiver. Nothing. Open, honest communication. This seems to be just, you know, we didn't get the final copy so that CC could review it and give feedback. You know what? Feedback happens along the way. Along the way is where it happens. And when you get ready for final submission, you have a lot of work to do. And you have tweaking to do. And you have to put attachments in order. And we have very specific requirements regarding from the U.S. Department of Education for the actual submission. So I make no apologies, Brad Oliver, about you not having the final copy to do one final review. Because quite frankly, this board did not have an approval process of the submission of this waiver. That is the simple fact. And I am not going to entertain an actual resolution that gives you authority to do those things and direct my department where it does not have authority to direct. So in proposing this resolution and potentially approving the resolution, the board is assuming powers and implying powers that don't exist and were not legislatively granted to the board by the General Assembly. Members of this board have repeatedly and correctly stated that the board's duties, as provided by legislative decree, are to establish the education policies for the state of Indiana. And yes, there are many items in this waiver that require you to take action. And I have committed to you over and over and over, I will not deviate for that. And I have never used this waiver to make policy. And you will not see me use this waiver to make policy. It is your job, it is our job as a board to direct the policy. The department in turn has given certain legislative authorities and duties to implement the policies established by this board. This resolution is an attempt to assume duties and authority given to the department to implement the policies established by the board. I cannot support a resolution that proposes that we as a board clearly overstep our authority over statute. While I reject this resolution because it exceeds our authority as a board, it is wasteful and would result in duplication of services to be assured that the Department of Education intends to comply with all state and federal laws outlined in this resolution. The DOE will also continue to provide the board with any updates regarding this waiver. So with that, I rule this out of order, and make no mistake, that's a ruling.
I would move to appeal.
Second the appeal of the chair.
I don't understand the order question. It's not
So-
a matter of order.
So I've ruled it out of order. We have an appeal,
On what grounds?
and we have a second.
On what grounds?
On all the grounds that I said that they don't comply. I just read it. That
Okay,
you have
you have an
have
ap-
no authority.
You have an
We have-
appeal
but
of
we
your
have
ruling.
rules. So where in the rules is it out of order? You
The
just said-
rules don't apply for this. The authority to do this resolution, to do what's enacted in there, what gives you the authority to actually carry out these items that you put in
Our
here.
operating rules don't apply?
Your
Is that your contention?
your procedures don't give you the right to direct the department to do
Okay.
these things.
So we have an appeal of the chair's ruling. I have a second.
And
We
just
need-
to be clear, I'm only.
So we have an appeal,
The
we have a
resolution
motion
is
and a
revoked.
second to appeal. So there's a motion to appeal the ruling of the chair. Any discussion on that?
Yeah,
Go ahead.
I would like to discuss it just a second.
I don't know that there
Yes.
is a discussion.
Well, you went on quite a... Listen,
I just
the-
simply
what-
need to,
what
I
we
simply
have-
need to
you
put the
have made a
question to us.
contention, Ms. Superintendent, that we have no role with this, but I want to go ahead and put this in context, and then we'll vote. The
Dan,
fact of the matter
Dan,
is,
I
you just
just-
went on a long tirade. I just want to say a couple
I'm aware
things.
what I did, and you may have your say here in a moment, because we haven't gotten to the appeal.
So we're going to get to speak, or is
The-
that overruled?
No, we're doing an appeal, and I looked at the board procedures, and it clearly states
Okay.
that when an appeal is made, we have a motion and a second and a vote. So there's a motion to, there's a motion to appeal the ruling of the chair. Roll call, please.
Can you just clarify what the, so we're overruling your decision?
I have ruled that
to-
this is out of order.
Okay, so that's what we're voting on.
Correct.
So a yes is to support?
And I have a motion to appeal the ruling of the chair.
Okay.
And a second. And so you are deciding, a yes vote means that you are, in objection to the ruling of the chair.
And then what happens?
A
Do
no,
we vote?
and then we're going to go to the motion.
Okay, thank you.
Discussion on the motion to appeal.
There is no discussion on the motion to appeal. Not according to our procedures.
who?
Not according to our procedures. According to our,
What authority is there no discussion on the motion to
according to our board procedures. So, please take the roll on the motion to appeal. A yes vote means that you are voting against the chair.
Against the ruling, not the chair.
Against the ruling of the chair. That is true, against the ruling of the chair.
It's against the ruling, we're not against you.
And I just wanted to provide some clarification, just, and, you know, I have reviewed the resolution.
Michelle,
at
I've not
issue.
called you to the podium.
We'd like our counsel to speak.
Just wait, please. I am going to do this appeal first.
And so that was actually why I got up initially. I read the procedures to always allow discussion and a motion, even though there's a special thing about you can appeal. I think that still follows typical motion practice. And I don't see any reason to preclude the discussion because we're just going to have it later, just to expedite it. I think we should just finish the
So
discussion.
here's what it says. I don't think there's any clarification needed.
Well, let's just have
If-
a vote.
If the chair makes a ruling and a member disagrees, the proper thing to do is to raise his or her hand, state that the member appeals the ruling of the chair. If another member seconds the appeal, then the chair puts the question to the members, who decide by a majority vote whether to sustain his or her ruling.
Call the
So the
question.
vote is to sustain my ruling. So I guess that's how I need to phrase the vote. So thank you very much, Bernice. So to sustain the ruling of the chair. So a yes vote would sustain my ruling. A no vote would then actually not sustain my ruling. Okay? Is
So-
everybody clear what they're voting on?
No. So if we disagree with your ruling, we vote no?
Correct. So the motion is to sustain, shall we sustain the ruling of the chair? Yes or no? Roll call, please.
Mr. Albert?
No.
Mr. Elsner?
No.
Dr. Gravis?
No.
Mr. Hendry?
No.
Ms. Neal?
No.
Mrs. O'Brien?
No.
Dr. Oliver?
No.
Mr. Walker?
No.
Mr. Watts?
No.
Superintendent Ritz?
Obviously, yes. I want to sustain the ruling of my chair, of myself.
Can I just-
Andrea?
I'd like to, so now we're voting
So
on
now
the
we're to
resolution.
the actual
Okay.
motion.
I regret that the politicization of this waiver submission has kept us from exploring the merits of the waiver itself. As I noted at the last meeting, the conditions imposed by the U.S. Department of Education on our ESEA waiver application reflect an unprecedented federal intrusion into the affairs of state government. Arguably, the conditions are more onerous than if we reverted back to the requirements of NCLB. Dr. Briggs' presentation this morning reaffirmed that impression. That stack that was next to Superintendent Ritz certainly did as well. I recognize that SCA 91 required the state to attempt to comply with the waiver conditions, but it also requires us to, quote, maintain Indiana's sovereignty. That suggests to me we have at least some obligation to study, observe, and question whether the waiver conditions themselves violate state sovereignty. I've been on the board for exactly a year, and I've met with staff and talked about issues such as assessment, ADF accountability, standards, and every single conversation comes down to, well, if the feds allow it, or we could do it this way to make sure we don't lose federal approval. I think we delude ourselves if we believe we set educational policy. Arnie Duncan has a lot more say than the State Board of Education, and I'm going to vote against this resolution for that reason.
So I believe we have a motion and a,
Superintendent.
we have a motion and a second on this resolution. Any more discussion?
Superintendent.
Brad, Brad, is that Tony or Brad?
That's Tony.
Tony, go ahead.
Tony, and then Brad wants to make a comment.
Okay, I just want to speak to the legal conclusion that the superintendent made, because I think it's inaccurate. And specifically, if we look at Indiana Code 20-19-2-14, which explicitly lays out the duties of the state board, one of the duties is, it says the state board shall do the following. And it says assure compliance with established standards and objectives. What we're dealing with the ESEA waiver is a compliance issue related to federal standards. And that is explicitly addressed by this statute. And furthermore, even if we look at Indiana Code 2019-2-8, and we look at subsection A5 of that, it says, in addition to any other powers and duties prescribed by the law, the state board shall adopt rules concerning the distribution of funds and revenues appropriated for the support of schools in the state. And whether or not we have that waiver directly affects how funds and revenues are appropriated to schools in the state and how they use those funds. Thank you.
I want to make a quick comment, please.
Brad?
Thank you. I just wanted to say before this motion goes to vote, I want to be very clear. The intent of the resolution, despite how it was articulated by the chair, was not meant to be a criticism of the State Department of Education. In fact, I am deeply grateful for the work that was done on a very short window to get that submitted. I'm also very aware it's already been submitted, but I am also keenly aware that we're not out of the woods yet, and there is going to be a need for additional actions, assuming the waiver is approved and extended, which I hope it is. The board will have statutory obligations to that. The resolution that we're about to vote on, just to be clear, is simply trying to frame where the board has responsibilities in providing an assurance that the board will have those opportunities to deliberate those things and act on them accordingly, pursuant to what Tony Walker just reviewed from section 2019-2. Thank you.
Dan?
Yes, I'm very concerned, Superintendent, your understanding of leadership, what's expected of you, and what our role is. We listened to you for quite a while there. The board, take the U.S. Department of Ed out of it and take the years of commitment to put standards in, high standards students should learn, proper testing systems, then to connect those with teacher quality and principal quality. The waiver has a lot to do with the policies we've set and quality of education. And things have been done unilaterally in your time here. Changing RISE, disbanding the Office of School Improvement, took a lot of months to get up with your outreach office, and that's supposed to be doing a job there. Delaying the work on standards, I sat, I think it was in this room, it was another tummy ache meeting, but we were trying to move a resolution on getting our standards rewritten. Brad Oliver makes a legitimate resolution, and you say it's illegitimate and walk out of the meeting. Well, then we're late. Then the Attorney General has to rule, of course it was legitimate, like so many things that you've brought into doubt. I don't like it either, but you have to realize in a leadership position, a large enterprise where we have important work to do, you work with people to get big things done for children in the future of our state. And all this board wants to do, and I appreciate Gordon's point, these are good guidelines. If you think you're doing them all, no objection. There's some, though, where we haven't had clear communication, we haven't had timely communication. Stack of papers was a mighty task last minute. Some of that could have been avoided.
That wasn't last minute, Dan.
And so it
That
was-
was on the way.
Well, and we were the only state in the union with the kind of condition placed on our waiver. So this board cares about the enterprise and the service to children. And so we're interested in our policies being implemented. And when I was listening to you, I guess you were saying, it's none of your business. And it's our mission. It's not our business. It's our mission to do these things well, and it's nothing to do with politics or with you personally. This is about us working together to make sure we're advancing education, people's futures, livelihood, the quality of their life, and appreciating art and citizenship depends on our group here providing excellent leadership. And so these instances where leaving meetings and just acting in such ways, that's not leadership. That's all we need from you. That's all we want. And it's never personal and it's never political. None of us serve here for that reason. We are here to do the work of education and serve our students. And that's the only thing we do. And I just have to disagree with you vehemently on your missive, I guess you shared with us today, because I just think it's totally off base of what this is trying to absolutely state and ensure.
Gordon?
Thank you. I don't disagree with you that the Indiana Department of Education owns this waiver submission. This is your responsibility to prepare and follow through with, and ultimately it rests with the Department of Education. However, this board is, recognizing the importance of the waiver, is deeply concerned about the success of the waiver extension. And so therefore, we've wanted very much to be involved and have input and help guide a successful waiver amendment submission. And so that's what I think we've tried to do, and I do believe that this resolution provides good guidelines and provides the board's input into the process to date and the process going forward. And that said, I do believe that what really matters is what's happened to date since the waiver has been submitted, and when can we expect updates? Who are we going to hear from relating to updates? Are we on track to be approved? When will we know so the schools can plan accordingly? And I'm grateful for all the work that's gone into it, but all the same, we, because of our strong interest in seeing the waiver extension be approved, we've wanted to be involved. So I think that's why we're here, and I don't see this as anything but collaborating and trying to put our best foot forward as a state as it relates to education policy. So, I'm on the final note. I think U.S. I would give high praise also to the U.S. Department of Education for their patience and willingness to work with the IDOE, and I would commend President Obama's bold policies that are helping us improve our schools here in this state. Thank you.
We have any more discussion? Call for the roll, please.
Mr. Albert?
I'm going to vote no because of the fact that it should have been done at the last meeting.
Mr. Elsner?
Yes.
Dr. Freitas?
Yes.
Mr. Hendry?
Yes.
Ms. Neal?
No.
Mrs. O'Brien?
Yes.
Dr. Oliver?
Yes.
Mr. Walker?
Yes.
Mr. Watts?
Yes.
Superintendent Ritz?
No. The next item on the agenda is the board operating procedures.
I move we approve these operating procedures. It's pretty well lined out in the resolution. This will clarify, a good example today of what we're doing, so I'd like to move it forward. Thank you.
And I heard a second. We are in
Second.
discussion. Before the vote, I want it to be known that since my office originated the idea of board operating procedures, which have... thank you. I do have public comment. You're supposed to keep me on track. The first person I'm gonna call 4 people. So sorry. Thank you. I have 4 people to call. Gail Sahairlis will be first. Jeff McDaniel will be second. Lynn Richard Nelson will be third, followed by Dr. Vic Smith.
Thank you.
And pardon me.
Gail Zaharolis with the Indiana State Teachers Association, and I should have said prior, I'm here because the president of ISTA could not, Teresa Meredith, so you're stuck with me. And I'll be on this one a bit more specific. You know, there's no czar of public education. Governor's not the czar either. But the state superintendent is the titular head of K-12 as elected by a significant number of voters. I know you're tired of hearing 1.3 million, so I'll just say significant. And statutorily, she does have the authority to be the chairperson of this board. And what I really want to kind of focus on is that a little bit over 6 months ago, I assume at taxpayer expense, a mediator was brought in to help you develop some of these policies, or all of these policies. And it was a mediator of your choosing, it's the board's choosing. And I know it's been a struggle at times, but I'm sure at times these procedures have really been helpful. What this looks like is that when you don't get your way on something, we're going to look at the procedures again and change the rules. And specifically, I want to talk about a couple of them. The one that changes who calls the meetings, I guess that's up at the beginning under regular meetings, used to say the chair shall determine the location in consultation with the board staff, and now it's the board staff doing pretty much all of that in consultation with the chair. So we're flipping there. But even more significantly is under the appealing a ruling section, because the new language says that this appeals procedure applies to all actions and decisions otherwise addressed in these board meeting procedures, including but not limited to, so it's anything, calling a special meeting or the addition of agenda items. And the addition of agenda items is a big one. Because basically, you can come in here on any day and add an agenda item with no public notice. That's wrong. It's just wrong. And then it goes on to talk about the interpretation of these procedures, which basically, it's a paragraph there, but it would allow you to flip-flop your interpretations from meeting to meeting of these board procedures. Because your vote occurs during the meeting. So the next meeting, you want to interpret something differently, you appeal, and you make that decision then. It really is bad government. It's bad public policy. It wasn't thought through. I think it was reactionary. It's not transparent. And we ask for you not to act on this today. It is not necessary. While it's been a struggle today, and while you find a way to get things done in your way, you don't need this on top of it all. And some respect should be given to the individual who put her name on a ballot and took that risk and was rewarded overwhelmingly. Again, we ask you to not act on this resolution. Thank you.
I am Jeff McDaniel with AFT Indiana. I'm Vice President of Legislation. I'm also a local president in Rushville. I just have a couple of observations. I have to admit this is, I think, on my second or third state board meeting and my first board meeting under the new administration. Just a couple of quick observations. Once again, I would like to agree with my colleague from ISTA. I really do think this is very, very poor government policy. It appears to me, and as she observed, sometimes somewhat painfully, I have not noticed a time when a single board member was not able to get their view into the discussion. It appears to me that there is no one preventing anyone from sharing their view. I guess most importantly for the members of AFT Indiana, I would like to say to you that while obviously this board shares an educational philosophy, that there are many of us in the state, many of, I think, that 1.3 million who voted for Superintendent Ritz, who do not necessarily share your educational philosophy. I have been active in politics for most of my 40 years of teaching. I have been very active in my own local. I wish everyone had done some of the things that my administration and I worked together. I think we could teach you a couple of things about working together. I like strong administration. I really like strong personalities, and boy, you got them. But those strong personalities have to find a way to find the middle ground, to find a consensus. As an old government teacher, I always try to remind people that when James Madison, author of the Virginia Plan, was asked, how do we make this work? And he said there are 3 rules: compromise, compromise, compromise. American government, and it appears to me the government of Indiana, an awful lot of very well-intentioned people seem to be forgetting that all of us are just here for a moment. There will be others who will come after you who will change everything you've done because they didn't like what you did. And they will be just as confident, my friends, that they are just as right as you believe you are today. Some respect for an elected official would be really nice. Thank you.
Next speaker is Lynn Nelson.
Good afternoon. I have to test my voice because I've been sitting for a while and evidently it's harder on my voice to be rested than to be speaking. First of all, thank you, Ms. Neal, for pointing out to us the importance of democratic citizenship and knowledge, liberal knowledge, which has a different meaning than liberalism, I'm sure you're aware. The idea that we knit ideas together so that our students don't become the servants of individual entrepreneurs or corporations, so that they actually can control their own lives. I want to point out the fact that Glenda Ritz is our elected superintendent of education. Now, we've heard again, more than 3 million votes, more than our governor received. My concern is the fact that we have large numbers of appointees of a particular administration and a particular point of view. We continue to add to those appointees by liberal spending of money for CC and other groups in order to develop the scope of a particular philosophy of education that we don't agree with. We have just finished the celebration of our independence of the 4th of July and the attainment of freedoms that we continue to fight for, including the right to vote. And as I sit here, I think about the fact that perhaps my vote, which was cast for Glenda Ritz, is going to be nullified by the board that sits in front of me. I mean, would we be here at 4 o'clock in the afternoon if Tony Bennett had been elected? Perhaps we would have been finished and rubber stamped at about 11 o'clock in this afternoon, and there wouldn't be an additional need for other educational bodies because everything would move through smoothly as you approve that. So less than 2 years ago, we voted for Glenda Ritz. She is our superintendent of education. If you continue with the motion that you want to put forth, maybe what we can do is celebrate Dependence Day rather than the Independence Day we finished. We can go ahead and simply acknowledge that we have turned more and more of our educational policies over to the guidance of Mike Pence and his beliefs, which scare me to death because I hear continuously about the fact that students should be human capital rather than human beings. Government Pence's own statements indicate that fact. Do you want, and the people in this room, do you want your children and grandchildren to be trained as workers, or do you wish to have them educated? It would be nice to hear more debates among you that differentiated between training for the purposes of other people and the education of individuals to control your own lives. In closing, Superintendent Ritz provides strong leadership to education in our state, and she represents the will of Hoosier voters. We will continue to watch. We will continue to monitor what you do. I am Lynn Richard Nelson. My PhD is from Indiana University. It is in history of education. It is in social studies education. I've taught here and in Europe, and I am a retired professor of education from Purdue University. Thank you.
Thank you. The next speaker is Vic Smith.
Thank you, Superintendent Ritz and members of the board. I'm Vic Smith, a retired educator. Thank you for this additional opportunity to speak. I oppose this resolution. It has all the appearance of a political move designed to reduce the powers of the duly elected state superintendent. And as been said, I urge you to respect the wishes of over 1.3 million voters who voted to give Superintendent Ritz the powers of the office, not thinking at the time of the election in 2012 that political attempts would be made to undermine and reduce the authority of the state superintendent. It is not surprising that there are winners and losers in State House debates on policy or on procedures. And there certainly have been winners and losers in this body in recent months and days. That is all part of our democracy. It is surprising that those who have lost a few debates want to use their supermajority status to reduce the powers of the state superintendent to guarantee that they will always win in future debates. This partisan measure is unseemly for the supermajority to pursue. It is a direct threat to our electoral system in our democracy, which carries an important concept that when voters empower an official by electing them, that elected official's judgments and policies deserve respect until the next election, when the voters can determine accountability in comparison to other candidates. So I urge you to defeat or withdraw this resolution, and I thank you.
Thank you. So we are in discussion. I want to say before we actually have a vote that since my office originated the idea of board operating procedures with the governor's office early in 2013, this resolution is stripping me, the statutory chair of the board, of my authorities within these board procedures, and it's especially insulting to me. Andrea?
I'd like to urge the board to vote against this. The public deserves an opportunity to comment on all agenda items that come before the board. And the current procedures set up a fairly straightforward process for placing items on the agenda. This resolution makes it too easy to add last-minute items, possibly controversial items, possibly ambush items, and that would deprive the public of sufficient notice to appear before us.
Any more discussion? Sarah, sorry.
I just would like to address the issue of the addition of agenda items. And again, I don't want to speak for the entire board, but I can speak for myself in saying that by no means do I see this as an opportunity to take advantage of a situation or to leave the public out of the potential to comment on important issues. I think we've all seen that there are certain occasions where something comes up that's of a timely nature that has to be addressed before a month's time. So I support that component, but again, with the premise that it not be something that as a board is taken advantage of, and that we remain professional and respectful of our constituents' rights to be here and to be aware of agenda items as they exist.
Gordon?
Thank you. You know, just to reiterate a point I made earlier, I really do believe this is much ado about nothing. You know, I've sat on this board for 10 months, and at times I felt like I'm sitting on a high school student council. And, you know, as somebody who sat on many public and private boards, you know, it's our responsibility to run our meetings in an effective and efficient manner. And unfortunately, you know, in my 10 months on the board, that has not been the case. We have seen a walkout. We've seen absolute confusion over what rules apply. We've seen no clear set of rules to follow. And I might add that if we were simply to adopt Robert's rules, the board would actually have a lot more authority to act. We don't have a parliamentarian to resolve disputes. We oftentimes lack information that's provided to board members in a timely fashion. We've had a refusal to acknowledge board motions. We've had, we've even been sued. I just think that as I read these proposed changes, they are legitimate, well thought through changes to our operating procedures that address issues that have come up in prior meetings. And again, I think that I've seen the calls of alarm that suggest that this board is stripping the superintendent essentially of her authority of chair of the board. And that is just an outrageous statement. It's untrue. And I think anyone who's reasonable who reads these and who has seen what's happened in the last 10 months would realize that these are intended to address issues that have specifically come before this board and need to be addressed. Again, it does nobody any good when our meetings become a media sideshow and for all the wrong reasons. We have to improve our discourse here, and I, for one, think that the controversy over these changes is really overblown. And so with that, I'll be voting for them.
Dan?
I appreciate your comments, Gordon. I'll just say a few things. And when I suggested we put this resolution together, I too have been on a lot of boards and served in a lot of ways and worked with a lot of excellent chairs. Frankly, I've never seen anything like this. It's not productive. It's not healthy. It isn't helping teachers or principals or students. And my hope was, by clarifying, actually making democracy work better, because you don't want unilaterally one person to say, well, we can't talk about that. That's not legitimate today. So maybe if we get some solid rules that would be based in solid governance that help us advance a mission, we can not only get more done, but maybe protect some of the relationships and the level of discourse. So I would note, too, the history on this. I've served on the board the longest, 10 years, and I've served a lot of people. And even when everybody's all one party, education will get some emotion going. There'll be a disagreement. And then when the Superintendent Ritz was elected, the governor reached out. We had some procedures. Those didn't work very well. We had big problems. So then we, in good faith, got a consultant in here that does national consulting all over the country. And I thought it was really good faith. And we put a committee together, and we didn't agree on everything. We kind of split a few things down the middle. And then after last meeting, it was clear we needed to do more for clarity. And the board is an entity on policy. The superintendent's power is in implementation and pulling through. We're not pulling back on that. We're talking about how the board operates. And so it is mischaracterized, with all due respect to our friends that testified. And it's been mischaracterized on some emails, or maybe misunderstood, whatever happened. This is not about taking authority away from the superintendent here to implement and lead education and implement the policies and implement the laws. But it does clarify how we're going to operate more efficiently, contribute to collaboration, and hopefully even a bit more conviviality and good relationships. So that's why I support this resolution. Call the question?
Well, no, not yet, because I think I need to let you know, whereby your resolution stipulates that the ad hoc committee meeting will take place today. I want to remind the members of the board that the ad hoc committee is charged with considering language changes to the procedures, and my hope is that the committee will present language to the board for action that will be both agreeable to both members of the board and to myself. And I heard Mr. Hendry speaking to the press just earlier today. He was in hopes that we would have such language brought by both groups to actually have some agreeable language. I am not prepared to address the proposed changes and appoint the members of the committee today regarding this matter, as stipulated in this resolution. I will commit to appointing this committee and dealing with the board procedures outlined in your resolution prior to the August meeting at a time and place of my choosing in accordance with the current board procedures. I apologize to the public for any inconvenience that this may cause, as a meeting was posted prematurely today prior to the vote that we're going to take to be held at the conclusion of today's board meeting with no regard for the chair and without my knowledge and without my consent. And so whereby you may pass this resolution, I am not going to appoint the members today to that committee, and I am not meeting today to resolve this issue. My staff needs to weigh in. We need to talk about this language, and hopefully if we come back, it's going to be something that's agreeable to both sides of the group here, because clearly there are sides. And so we need to move forward on this piece. You clearly have the right, Dan, to ask for an ad hoc committee to deal with board meeting procedures, as is in our board meeting procedures. So with that, we will call the vote.
What's the motion?
The motion is to approve the
amendment.
resolution.
Sorry, I want to make sure. I'm going to say no, and the reason why, and I'm going to clarify on the reason no, is I felt the board policies and procedures were followed today, and in that good faith, I think that we ought to stay with it.
Mr. Elsner?
Yes.
Dr. Frazier?
Yes.
Yes.
No.
Yes.
Yes. Yes.
Yes.
No. We're going to take a short recess before we get to our discussion items. And we will return at 4:35, 10 minutes.